Greetings, everyone. My name is Raj Reddy, and I direct the Animal Law Program at the Center for Animal Law Studies at Lewis and Clark Law School. It's my pleasure to serve as the moderator for this ABA International Animal Law Speaker Series event, which is co-organized by two international animal law ABA groups, the TIPS Animal Law Committee's International Subcommittee, which I chair, and the International Animal Law Committee, which is chaired by Caitlin Labarge. If you're interested in learning more about the ABA's International Animal Law Committees and efforts, please don't hesitate to contact either of us via the two emails that I'll drop now into the chat. So with that said, welcome to this panel presentation on the Estrellita case and the rights of animals under the rights of nature. On January 27, 2022, the Constitutional Court of Ecuador granted judgment, which it titled The Rights of Nature and Animals as Subject of Rights. In that case, more popularly known as the Estrellita case, concerned a precedent-setting legal battle over the possession of a charango monkey, with the Constitutional Court's ruling establishing a binding jurisprudence over the rights of certain non-human animals. And since numerous outlets have announced that Ecuador is the first country where animals enjoy proper legal rights, and this panel will examine this and other sort of contours of this case and shed light on Ecuador's new jurisprudence as to the rights of nature, as to the rights of animals as part of the rights of nature. Our distinguished speakers are Macarena Montes Franceschini, an attorney and doctoral researcher at Universitat Pompeu Frabra's Law Department. Macarena has been a visiting researcher at the Max Planck Institute for Comparative Public Law and International Law in Heidelberg, and a rights research fellow at the Brooks McCormick Jr. Animal Law and Policy Program at Harvard, where she will begin a visiting fellowship in 2023. Next, we have Marcia Condoy Truyenque, who is an animal law LLM candidate at Lewis and Clark Law School. Marcia is a Peruvian lawyer with work experience in labor law and constitutional law, and investigative experience in international law, international human rights law, and animal law. And she directs the animal law area of Preston Plus Law Firm, the first firm in Peru with a specialized area in this particular matter, as well as has previously served as Peru's correspondent for the Argentinian organization AFADA. Thank you so much, Macarena and Marcia, for sharing your insights with us today. And for our audience, our panelists will be presenting for approximately 15 to 20 minutes each, after which we'll open up the floor to audience Q&A, which you can enter into the chat or send to me as a private message. With that said, please, Macarena, feel free to share your screen and begin.
Thank you. Thank you so much for the invitation. I'm really happy to be here today talking about this really fascinating case in Ecuador. So I'm going to share my PowerPoint presentation. Can you see it? Yeah. Yeah, can you see it? And can everybody hear me well? Yes? Yeah, okay. Estrellita's case. Let me start by giving you the facts about this case. So Estrellita lived with a human family for 18 years. She lived with them since she was 1 month old. When she was 18 years old, she was confiscated by the Ecuadorian Environmental Authority due to Section 147 of the Organic Code of the Environment, which prohibits the breeding, possession, and commercialization of wild animals. So the Environmental Authority quarantined Estrellita at the San Martin de Baños Zoo, where she died on October 9, 2019. Before learning of her death, Estrellita's human family filed a writ of habeas corpus on her behalf, requesting her return and that a wildlife license be issued to legally keep her at their home. The lower court and the Court of Appeals denied the writ of habeas corpus. Despite Estrellita's death, the Constitutional Court of Ecuador selected the case to develop binding jurisprudence on whether animals are subjects of rights protected by the rights of nature and the Ecuadorian Constitution, and the scope of writs of habeas corpus regarding the protection of non-human animals. So during the trial, during the proceedings before the Constitutional Court, several individuals and entities filed amici curiae to support Estrellita's case. So this included a joint brief presented by the Brooks McCormick Jr. Animal Law and Policy Program at Harvard Law School and the Non-Human Rights Project. And this amicus was prepared by Professor Kristen Still, attorney Stephen Wise, Kevin Schneider, and me. And in a few minutes, I'll tell you a bit about our amicus. 7 of the 9 judges of the Constitutional Court decided to recognize Estrellita as a subject of rights protected by the rights of nature. So it was a pretty successful case. So Ecuador is a pioneer worldwide for recognizing nature, or Pachamama, as a subject of rights in its 2008 constitution. The incorporation of the rights of nature in the Ecuadorian constitution materialized the indigenous community's claim on harmony between humans and nature, as well as the growing demand of broad segments of the Ecuadorian population against the accelerated destruction of nature, mainly caused by extractivism. Hence, the Constitutional Court has had to interpret these new provisions, and in doing so has recognized that nature has intrinsic value regardless of the value humans assign to it. In recent years, the court has issued historic rulings protecting nature against extractive activities represented by powerful lobbies such as oil and mining. The court's rulings have not only protected nature as a whole, but also its elements, such as mangroves and forests. Initially, nature had been linked to places. However, the concept of nature is broader than places because it is understood as an interconnected system of living and non-living beings that are constantly interacting and that depend on each other. Concerning animals, the court had only referred to them as species, since the traditional doctrine in environmental law and the rights of nature only focuses on species as part of an ecosystem, not on individual animals. But on January 27th, in a historic ruling, the court departed from this doctrine, recognizing individual animals, in this case, Estrellita, a woolly monkey, a subject of rights protected by the constitutional rights of nature. It is important to note that Estrellita's case is the Constitutional Court's first ruling that recognized animals as subjects of rights in Ecuador. So Estrellita was a woolly monkey, and woolly monkeys are the most threatened primate species in the northern Ecuadorian Amazon due to habitat loss, hunting for food, and the illegal pet trade. Woolly monkeys have a hard time preserving their population because they have a low reproduction rate and do not tolerate the alteration of their habitats or human presence. So the Constitutional Court of Ecuador's rulings on the rights of nature challenged the traditional anthropocentrism of law, especially environmental law. In this sense, the Constitutional Court has established that nature has intrinsic value, which means that it is an end in itself and not just a means to achieve human ends. In the recent Los Cedros forest ruling, the court clearly stated that the intrinsic value of nature implies that humans should not be the only subjects of rights, nor the center of environmental protection. In other recent judgments, the Constitutional Court has also considered that nature shares the status of subject of rights with its elements, including animals. So respecting the rights of nature implies protecting all species, even those humans consider ugly, unpleasant, or useless. In Estrellita's case, the Constitutional Court not only recognized law's anthropocentrism, but also criticized law's speciesism, as humans are considered the center of the legal system while denying the protection of nature and animals. So there are some positive implications of Estrellita's case. First, the court recognized that sentient animals are subjects of rights. Then the court argued that animals are part of nature, so they are protected by the constitutional rights of nature. The court acknowledged that animal rights constitute a specific dimension of the rights of nature with their own characteristics. This means that animal rights related issues are now a matter of constitutional law in Ecuador. Second, although Estrellita died and the harm she suffered cannot be relieved, the court still recognized every moment during Estrellita's life where humans violated her rights. First, Estrellita's rights were violated when she was poached, and her mother was probably killed to take Estrellita, as this is the regular practice when hunting primates. Second, her rights were violated when she was kept with a human family for 18 years. Third, her rights were violated when she was confiscated and put in quarantine in a zoo without considering her individual circumstances, especially the fact that she had only lived with a human family. So this is a very important aspect of the court's ruling, because it is not common for courts to acknowledge with such detail all the harms that humans inflict to animals. Third, one of the most important arguments that we made in our amicus was that species are made up of individual animals. So what happens to one animal can significantly impact the species. Hence, it would be arbitrary to decide the number of animals needed to activate the rights of nature. Would 2 animals, 3 animals, 15 animals, 100 animals be enough? So even though this argument sounds logical, it was a complex argument to make due to the Constitutional Assembly's debate on the rights of nature in Ecuador, scholarship on environmental law and even on rights of nature, and even the Constitutional Court's case law, because all of these different things always focused on species and not on individuals. This argument is critical because focusing on species protection has been clearly insufficient, considering we are going through the 6th mass extinction of animals. Luckily, the court decided to challenge this traditional view and argued that animals are not only protected from an ecosystemic perspective, but also as individuals. This change is a huge win for animals because from now on, the rights of nature provisions in Ecuador will be used to protect individual animals that are taken from their habitats, for example, for the illegal pet trade or zoo trade, or hunted for their fur or as trophies, among many other cases that harm animals in Ecuador. Fourth, the court outlined some rights that animals hold. These rights include the right to exist, the right not to be hunted, and the right to the free development of their animal behavior, freedom, and habitat, among many other rights. Some of the rights refer to animals that live in the wild, but other rights that the court mentioned, such as the right to food, the right to health, and to live in harmony, apply to all animals. We have to remember that the court recognized all sentient animals as subjects of rights and recognized them as part of nature. So, for example, farm animals should also benefit from some of the rights mentioned by the court. The court also recognized, for example, that animal species have the right to exist. We could think that this right is not novel because this was recognized in the 1992 Convention on Biological Diversity, even though it was not formulated in the language of rights. However, we must interpret this right to exist with the court's recognition that rights of nature protect individual animals. So we could argue that individual animals have the right to exist. The court also recognized wild animals' right not to be hunted, poached, or captured, which was also prohibited by the Organic Code of Environment. It is important to note that hunting or poaching only one animal cannot activate the rights of nature, even if that species is not endangered. Before the court recognized the constitutional protection of animals through the rights of nature, poaching, hunting, and capturing wild animals was regulated by the Environmental Code, but now it is also a matter of constitutional law. The court also recognized animals' right to the free development of their animal behavior, which includes not being domesticated and not being forced to assimilate human characteristics or appearances, the right to behave according to their instinct, the innate behavior of their species, and those learned and transmitted between the members of their population, the right to develop their cycles, processes, and biological interactions freely. This right is fundamental considering that woolly monkeys are poached and sold in the illegal pet trade. The court formulated this right in quite a unique way because it implicitly recognized that animals have their own culture and have the right to pass it on to the members of their populations. The court also recognized that animals have the right to buen vivir, or good living, based on the indigenous conception of summa causae, that is, living in harmony with nature. This concept could open the door to future cases against certain human activities characterized by the exploitation and abuse of animals that are clearly against living in harmony with them. Finally, the court stated that wild animals have the right to habitat. Although the court didn't expand on this right, If this right is developed and taken seriously in the years to come, it could really change the situation for animals. Could we recognize that animal communities own their habitats in the future? Or maybe apply Donaldson and Kinzika's theories of that humans should recognize wild animal self-determination and not intervene in their communities and habitats? So hopefully the right to habitat is not a symbolic declaration, but becomes an enforceable right to ensure animal survival. Fifth, and these two last implications are pretty important. The court ordered the Ministry of Environment to develop a protocol that considers the circumstances of captive wild animals to ensure their protection. Therefore, the environmental agency will proceed according to a confiscation protocol that considers the specific circumstances of the captive animal to avoid repeating what happened to Estrellita, as putting animals in zoos is not always the best option for the animal. Finally, the court ordered Congress to prepare a bill on animal rights based on the ruling. This law should include and develop the rights outlined in the judgment and apply to all sentient animals. This is a relevant implication of the ruling for animals in Ecuador because currently there's no law on animal rights or even a general law on animal welfare, just the criminal code and some environmental code regulations. So an important aspect of the judgment is that the court talked about animal rights being interpreted on the basis of the interspecies principle and the ecological interpretation principle. So usually when a court argues that animals are subjects of rights, they do two things. First, they explain that animals hold different rights, so they are different from humans, even though they are also subjects of rights. And second, courts usually fear the slippery slope that granting some animal rights will ban animal agriculture, biomedical research, and other activities involving animals. So the Constitutional Court did both. So the court argued that many animals are sentient and recognized that humans are sentient too, but possess other characteristics that distinguish them from non-human animals. And then the court explained the interspecies principle, establishing that the protection of animals focuses on the characteristics and evolutionary processes of each species. So for example, the right to protection of migratory routes can only be guaranteed to species that migrate. So in other words, the court is saying that animals hold different rights. So a woolly monkey will have different rights than a parrot or an alligator or a human being. So regarding the slippery slope, the court defined the principle of ecological interpretation as respecting the biological interactions between species and individuals of each species. The court argued that a predator that kills its prey does not unlawfully violate the prey's right to life, and this situation applies to humans and the right to feed as omnivores. The court also justified other activities involving the use of animals. So it's important to note two things about the slippery slope argument. First, the Constitutional Court did not say that humans will always have the right to eat animals based on the ecological principle, but stated that the biological interactions between species must be respected. So we could think that if humans change their biological interaction with certain animals in the future and stop eating them, then the ecological principle will not support meat eating. Second, the slippery slope argument not only comes up in rights of nature cases like Estrellita's, but also in animal rights cases like the Non-Human Rights Project's cases, where judges usually ask what effects the recognition of the animal as a legal person with basic rights will have on other activities regarding animals. For example, in Chucho the Andean bear's case in Colombia, which was not a rights of nature case, the court that granted Chucho the habeas corpus also stated that this didn't mean that everybody would now become vegan, and even wrote a pretty sarcastic paragraph against veganism. So the problem with animal agriculture, biomedical research, even invasive species comes up when talking about animal rights. Hence, the slippery slope problem is not a problem per se of the rights of nature framework, but a problem of arguing for animal rights in any framework, because animal exploitation is unfortunately entrenched in our society and economic system, and people resist changing their relationship with animals. So the fact that the Constitutional Court of Ecuador argued that the interspecies principle and ecological principle imply that animals are different from humans and that humans can continue using animals in certain ways is not really the novel aspect of this case. Courts usually acknowledge that animals have different rights from humans and address the slippery slope to protect their rulings from higher courts, from the state, or the public opinion. And considering that the Ecuadorian government is trying to implement an extractivist agenda and sees rights of nature like a huge obstacle for this, the Constitutional Court has to be very strategic and smart about its rulings, so they do not become a mere symbolic declaration with no practical effects or deemed as ridiculous by legal practitioners and civil society. So a judgment in Ecuador today that bans all uses of animals is impossible, but the Constitutional Court did open the door to improving the protection of animals in general, especially wild animals, by recognizing them certain rights that are there that will have to be developed, and for biological interactions between humans and animals to change. So as animal rights advocates, we have to be pretty strategic of what we do in court. We usually acknowledge that judges are not vegan or even sympathetic with the animal rights movement. But we also know that animals are currently suffering and dying, like right now. So even if a court ruling does not end all uses of animals and turn our societies or make our societies closer to vegan societies or vegetarian societies, courts do have the power to make things better for animals in each case that they receive. So for example, in Argentina and Cecilia the chimpanzee's case, that case might not have saved all chimpanzees in Argentina or may not have stopped huge pig farms from being built in Argentina, but it did save Cecilia's life, who is currently living in a sanctuary in Brazil. So the Constitutional Court of Ecuador took a step forward by recognizing all sentient animals as subjects of rights with constitutional rights under the rights of nature, and by recognizing that animals have certain basic rights. Even though humans may continue consuming animal products, the rights of nature framework does improve many animals' situation in Ecuador, because attorneys now in Ecuador have constitutional rights to argue on behalf of animals. Before this ruling, animal rights could basically not trump humans' constitutional rights, but now animal rights through the rights of nature could trump other constitutional rights depending on the circumstances. For example, the court recognized that the writ of habeas corpus can be an appropriate tool to protect animals in certain cases, which is a considerable advance because it will help captive animals in zoos and labs and circuses, among others, which is precisely what the Non-Human Rights Project wants to do in the US, but not in the framework of the rights of nature. Additionally, the fact that the Constitutional Court, which is the highest court in the country, has recognized animals as subjects of rights means that the government, Congress, and other courts should act accordingly. Before Estrellita's case, animals in Ecuador had no constitutional rights, were not recognized as subjects of rights, were not protected as individuals in environmental matters, and were denied the writ of habeas corpus. So the rights of nature framework has objectively managed to improve things for animals in Ecuador. This does not mean that the rights of nature is the only way to achieve animal rights, but it may be a useful approach, as the Ecuadorian case shows. So to finish, the rights of nature and animal rights frameworks can complement each other to make things better for animals. Rights of nature are growing fast in many countries, much faster than the recognition of animal rights on their own. So we should not miss the opportunity to advance animal rights through the rights of nature, because the protection of animals is genuinely urgent. Thank you for your attention. Here's my email in case anybody wants to contact me, because I don't check social media. Thank you.
Thank you so much, Macarena. And Marcia.
Yeah, I'm here. Good morning, everybody. I will. Yeah, can I start?
Yes.
Thank you. I'm sorry. Well, good morning, everybody. My name is Marcia Condoy. I am I am an animal lawyer, graduated in the LLM of animal law in Lewis and Clark.
Marcia, just really quickly, I think your video is off if you want to turn it on, if you're able.
I am with my, yes. Well.
We can hear you, but we can't see you.
Okay.
Oh, there you go.
It's okay. Well, good morning, everybody. My name is Marcia Condoy. I am an animal lawyer, graduated in the LLM of animal law in Lewis and Clark. And thank you so much, Macarena and Dr. Reedy, for organizing this event. I recognize the importance of the Estrellita case. For me, and I think that for many people, the Estrellita case is a very important precedent because we are recognizing that animals can be legal subjects. Nevertheless, given the importance of this case, I would like to present a critical perspective to it, because from my point of view, the rights of nature framework is not an appropriate pathway for rights for animals for the following reasons. Well, as Macarena explained, the court has recognized animals as legal subjects under the rights of nature. The rights of nature is a framework which recognizes nature as a legal subject and with corresponding rights. And the main goal of the rights of nature is protect the environment from harm, from pollution, exploitation, etc. The main value is nature, is the environment. Under this framework, the Constitutional Court of Ecuador has recognized a set of rights for wild animals. The court didn't express that nothing about domesticated animals in relation to which rights correspond to them, but on the Estrellita case, we know that all animals now have rights, but the court only mentioned what are the rights for the wild animals, and are the rights that you are seeing in the screen. I would like to emphasize in the right to life, physical integrity, the right to exist, to not be hunted, etc. These are not a definite numerous clauses list, because the court say that in the future, new rights can be recognized for animals. But here comes what is interesting for me. As Macarena explained, the Constitutional Court of Ecuador has established that these rights for animals have to be assessed from two principles, the interspecies principle and the ecological interpretation principle. These principles are interpretative principles, what means that they will lead what is the meaning of these rights. As Macarena explained previously, the interspecies principle focus on what are the characteristics, what are the necessities of the animals according to their species. Macarena mentioned that the court gives as an example that the right to respect and conserve the areas of distribution and migratory routes is a right that can only be protected from a species of animals with migratory behaviors. Another good example of the interspecies principle we can find in a case in India, where the High Court of Delhi recognized that birds have the fundamental right to fly. And that is very interesting. Here I would like to say that we can go forward and think that animals also it will be very important to consider individual interests of animals. And in this point, I would like to say that the capabilities approach of Amartya Sen and Martha Nussbaum will be very useful. So we can consider animals as a species, but also in relation to their specific individual circumstances and necessities and desires. Well, the problem for me, and here is my critical perspective, comes with the principle of ecological interpretation. The principle of ecological interpretation establishes that biological interactions that exist between species and individuals have to be respected and protected. In the judgment, the court has recognized the importance of biological interactions as the foundation of the equilibrium of ecosystems, and has established that public authorities are obligated to ensure that biological interactions maintain their natural balance. What are these interactions? Competition, antagonism, commensalism, mutualism but also that biological interactions where some individuals benefit from others by causing harm or them. That is predation of parasitism. From an environmental point of view, the maintenance of biological interactions and natural balance is a plausible goal. Nevertheless, from an animal rights perspective, this point of view, the maintenance of natural balance and biological interactions could be problematic. Why? Well, we can understand why from two examples that the court has mentioned in the case, in the Estrellita case. In paragraph 102, the court said, when a predator kills its prey in compliance with the trophic chain, the right to life of an animal is not illegitimately violated. The statement that the court gives immediately after, in paragraph 103, draws my attention, because the court said that as human beings are predators and being omnivorous by nature, the right to feed on other animals cannot be forbidden. So, human interest in consuming animal protein has been declared a legitimate activity that can easily undermine the right to life, the right to physical integrity, or the right to exist, or the right to not be hunted of animals that the court recognized, but the court recognized that also humans have interest in consuming these animals. But eating animals is not the only human practice that the court has legitimized. We will find that in relation to domesticated animals, the court has mentioned that they can be used for transportation, for clothing, for footwear, recreation, and even leisure. According to the court, the domestication of animals has served to enable humans to provide transportation, help in work, for clothing, for footwear, and even for recreation and leisure. In relation to wild animals, the court says that they can be captured for ex situ conservation. That is, we can take wild animals from nature to zoos. And because ex situ conservation enhances opportunities for environmental education, research, and scientific development. And invasive species also can be exterminated in the name of ecosystem balance. The court has established that National Environmental Authority may carry out necessary actions to control species populations, especially when it is a matter of eliminating invasive, exotic, or introduced species that may endanger the balance of ecosystems. So, my point is, what is the purpose, what is the point of recognizing rights of animals if these rights can be easily undermined by any human interest? As we can see, the court has done that biological interactions and natural balance work as restrictions on animal rights. And from a rights theory, that is incorrect because restrictions cannot be easily imposed on rights. And here I would like to take a moment to explain how works restrictions on rights. We have to understand that there are some fundamental rights that cannot be limited, that cannot be restricted. They are considered absolute rights. Even when there are compelling reasons, those rights cannot be limited, cannot be restricted. One example is the provision of torture, but also we have the provision of discrimination, the provision of arbitrary detention, of forced disappearance. That are examples of human rights that are absolute. But the most of rights can be subject to restrictions. Nevertheless, these restrictions cannot be imposed arbitrarily. Rather, they have to fulfill with a standard. And that standard asks that three elements have to be satisfied. The first is the legitimacy. The legitimacy means that the restrictions must correspond to a legitimate objective. There must be a very strong reason to impose restrictions on the rights of an individual. The second element, the second condition, is legality. Legality means that the restriction must be in accordance with law in a transparent way and with legal safeguards to avoid any risk of arbitrariness. And finally, proportionality. The restriction must be proportionate and necessary for the fulfillment of the objectives pursued. The restrictions should not go beyond what is necessary for the objective to be realized. This is a regime. This is an international regime to impose restrictions on rights. Of course, we can find some variations in relation to the different legal systems. For instance, in the most of countries, the right to life is an absolute right, but not in the case of countries where there is death penalty, for instance. But the point here is to establish that restrictions cannot be established in an arbitrary way. They have to fulfill these three elements, these three conditions: legitimacy, legality, and proportionality. Nevertheless, nothing of this has been mentioned in the Estrellita judgment. Rather, and this is my biggest critique, the court has found in biological interactions an argument that justifies to continue use animals for human interests, even for leisure. And here, when I was reading the case, what comes to my mind is that the biological interactions and natural balance and the ecological interpretation principle is the new necessary suffering. It's the same problem of necessary suffering in welfarist regimes, but in this case, it's happening inside of the framework of the rights of nature. And this is not a standard that we will accept for human beings, because if we will accept that natural balance and biological interactions are legitimate restrictions to human rights, for instance, we will be unable to ask states to comply with vaccination campaigns under the rights of health, because parasites and bacteria and viruses are very natural, but that does not imply that we have the right to have health. And that is the point of the rights, of the development of rights, to achieve a certain point of development, both a moral development and moral correction, but also to try to benefit individuals. Because to accept that natural balance, to accept that what is natural, that natural balance is correct, that biological interactions are inherently correct, is to fall into a naturalistic fallacy. That is, for instance, to say that because a woman can have children, they are obligated to have children, and or some other kind of obligation from them. So I consider that rights of nature is an appropriate framework for protect the environment. In the first moment, I was very hesitant to accept rights of nature, because I consider in the past that rights can only be saved from sentient beings. But that is not necessarily the case. I consider now that rights of nature are an appropriate framework, but only for protect elements of the environment and subjects that are not like animals and humans, that are sentient beings. Because to protect an individual is very different to protect a biotic or other elements of the environment. Other elements of the environment depends on protection of biological interactions and their natural cycles. But to protect individuals with individual interests is different. Individuals need rights and protections that will recognize them with autonomy, with inviolability and intangibility. Under this interpretation, I consider that, and this is a graphic that I made that could explain how are the rights of animals and rights of nature currently in the Constitution of Ecuador. They are totally separately. So the right to life that the Constitution recognized in Article 66 to human beings, the right to life to humans, is very different from the right to life that the court has recognized for animals. And it's not merely a difference that is based on this principle of interspecies principle. There is a substantially different form of rights. The structure of the rights is different, because the rights of humans currently have inviolability, autonomy, and intangibility, but the rights of nature, no. Or at least the rights of animals under the rights of nature, no. And this separation reminds me this classical dualism that we find when we study animal law and animal legal philosophy. That on one side are humans, and the other side are the rest of the nature. And that is what I am. It's very difficult to accept to me. So, what is my proposal? I would like to enhance foster the animal lawyers to recognize that even when the rights of nature could be very useful for protect animals, it's not the pathway that we have to follow. Rather, we have to come back to ask and to fight for full rights for animals. First, rights for animals in an independent way from rights of nature and rights for humans, towards a recognition of rights for animals that derive from the same foundation of the rights of humans. That is, rights that derive from dignity or from liberty, rights that could derive both for humans and animals from sentience, from basic necessities, or for capabilities or vulnerability. Whatever foundation that we find for rights, humans and animals should share these rights as a whole. Well, that is all, and I hope that it will okay. That is my social media and my email. Thank you so much.
Thank you so much, Marcia and Macarena. To our audience, if you have questions, you can feel free to raise your hand or just go ahead and unmute yourself or submit a question through the chat. I will go ahead as those start to trickle in. Well, first, again, thank you both for these really compelling presentations. It's so interesting to see how your views both complement and diverge with respect to the jurisprudence offered to us by our constitutional court. And so let me start with this. Macarena, you observed that the court required, in its judgment, required the legislature to craft a Bill of Rights that formalizes its sort of ruling in this case, or the points sort of posed in this case. And Marcia, you've nicely touched upon some of the loopholes that you found in the court sort of granting of rights to animals under this rights of nature paradigm. Excuse me. And so my question is, in light of the court's judgment and the Macarena, as you observe, sort of the extractivist stance of the current government, what fundamental rights framework for animals should we as animal advocates anticipate coming from this government?
Well, I think in Ecuador, we have to distinguish. I think the government has no intention in recognizing any framework of animal rights for animals, but the Constitutional Court has considered animals as part of protected by the rights of nature. So the Constitutional Court is the one that has offered at least some framework. Now we have to see in Congress what happens when they start writing the bill, because as we know, powerful lobbies are against animal rights. So we have the animal agriculture lobby, every lobby practically related to every activity related to animals. So we have to see how that plays out in Congress. But so we can't really know for now. I mean, the court said that the rights that it mentioned in the judgment should be incorporated in this bill. Obviously, the court also said that through these principles of interspecies and ecological interpretation that we know that have these problems that Marcia especially mentioned. But the thing is that Ecuador right now doesn't even have an animal welfare law. There's nothing in Ecuador right now. There's just some articles in the criminal code against animal cruelty and that protect the sexual integrity of animals, for example. But and there's other regulations in the environmental code on hunting wild animals and things like this related, like to the Estrellita case. So even if there's an animal, in the worst case scenario, even if Congress comes up with just an animal welfare law, at least now there's going to be some very, very minimum standard that there isn't in this moment in Ecuador. So we could hope that at least something should improve the current situation that is, because there is nothing right now. So we could hopefully, we hope that animal advocates can really work their magic in Congress to get the best law possible that ensures rights for animals, and not only welfare regulations, but, and it should, because the court recognized animals as subjects of rights. So it should be a law that recognizes animals as holders of rights and not as just animal welfare regulations. But I think we just have to wait and see what happens. It's hard to say right now.
Mm-hmm. Yeah, totally. And I would like to add to that, when the court say that the Congress of Ecuador has to enact an animal law protection, also there will remain this judgment. The judgment has constitutional value. So as this is a constitutional precedent that is like is part of the Constitution in some sense. So a positive thing from the Estrellita case is that all the guarantees and recognition of rights that animals have now under the Estrellita case have the same value that a constitutional provision is, not merely a statutory provision. So that is very important, because now the balancing between constitutional rights and the rights of animals under the Estrellita case will be more equal. But also we will have this ecological principle present. So the ecological interpretation principle is what wake the rights of animals under the rights of nature. For that reason, I put attention in that principle.
Thank you. Questions from the audience? Yes, Carolina.
Hi, good afternoon. I would like to thank you all for organizing this event. The Estrellita case has been in my radar for a while, and I hadn't had an opportunity to learn more. And the dynamic of this event, of having the presentation, the analysis was great. So thank you. And I wanted just to invite you to also look at the Vaquejada case in Brazil. There is a very interesting discussion. That court is a Supreme Court case, because in Brazil, we have the constitutional provision of a balanced environment for current and future generations. And within the framework of balanced environment, there is a duty for the government to prevent animals from suffering. And there is a very fruitful discussion within this court decision about the difference between environmental protection, individual animal protection. And the court, in this case, recognized that when we talk about individual animals, we need to protect not only from physical suffering, but from mental suffering. So it's a beautiful piece of work from the court, and I invite you to have a look at this, as it can be enlightened for your further discussion on the Estrellita case. Thank you.
Thank you. Hey, Carolina, can you write the name of the case in the chat, please?
Yes, sure.
Thank you.
And you are welcome. I can send you your way if you need it.
Thank you.
Yes, please. And you can also, if you have a file, you can drop it into the chat as well. Thank you, Carolina. One question. So in some ways, this case is complicated by the fact that Estrellita had already passed away by the time, the past owners filed their habeas petition. In other ways, however, the court is afforded considerable freedom in framing its jurisprudence, in that, at least for this case, they don't have to deal or worry about any of the real life, outcomes. So with that said, in your respective understandings of this case, had Estrellita been alive, what do you think the court would have done? Would it have transferred her to her previous owners or to a third party, such as a sanctuary? What would have been sort of the upshot of this case?
Mm-hmm. Yeah, one of the as we were presenting, one of the rights is that I will read the name of the right is the right to not be object of humanization processes or forced to assimilate to human characteristics of appearances, and also the right to not be domesticated. So I think that in some way the court could say the animal is a wild animal and it cannot be with you. It has to be in nature or in a center for rehabilitation. And that is the problem, to see animals merely as a species or as a whole, because there is this duality, wild and domesticated. And also there is another group that we know that we know as liminal animals. But we think that animals can remain in these three groups forever. But that is not the case, because animals have flexibility in their minds. So I think that animals can flourish in different environments. Of course, that the better for Estrellita was to live in nature. But we have to remember that Estrellita was living with Anna for 18 years. So the only good place for Estrellita, it was the family, it was with Anna and the family. And that is that, I don't know, I think that the court could say that, and Estrellita could live in a rehabilitation place, because to do the contrary, to return Estrellita to Anna's house could imply also to promote to have wild animals in private houses, no, with normal people, with individuals. But it's a difficult question. I think that if we have to see animals as individuals and assess the specific cases and specific circumstances. Only that.
So I think that if Estrellita hadn't died, I think the court should have consider her individual circumstances, as it said in the judgment. So what are her individual circumstances? She lived with a family for 18 years. She was poached from her habitat when she was a month-old. So Estrellita was a woolly monkey that doesn't know how to interact with other woolly monkeys. She only knows how to interact with humans. So I don't think that leaving her in a human house would have been the correct thing to do, but I don't think that putting her in a zoo was the correct thing to do either. So I think the court maybe should have investigated maybe a sanctuary. Maybe in Ecuador there's a sanctuary for woolly monkeys that have been, I don't know, used for entertainment or as pets or whatever, that has good conditions for them. But at the same time, the court should acknowledge that Estrellita had a very strong relationship with her human family. So maybe the transition of Estrellita to the sanctuary should have included the family. So for example, having the family accompany Estrellita constantly during the first days at the sanctuary, during the first months even, accompanying her, being with her, next to her, and being part of a process. So it would be respectful for Estrellita in both ways, considering her past, but also considering that maybe Estrellita would be better would be better off in a sanctuary instead of a house in a city in Ecuador. So I think the court should have done something like that, but always obviously considering her specific circumstances and with the help of experts, obviously. And there are experts in woolly monkeys that have studied woolly monkeys in the wild and that know what they need and what they require.
Thank you. We have one question in the chat from, or a couple questions from Daryl in the chat. I'll go to this last one. Why does domestication, or turning wild species into pets and their humanization, contravene the integrity of wild animals, but not traditional domesticated animals such as cows, pigs, sheep, who are eaten, and dogs and cats who become sort of pocket pets?
Good question. what happened is that we have to focus in the status in what is the present, and in the present we have three groups of animals in a general way. Wild animals that live very far from human beings, the liminal animals that live near to human beings but not as part of their family, and domesticated animals that live in close relation with humans. But I don't consider that domestication in a first moment, years and years before, 8,000 years before, it was inherently bad, because animals have also benefit from the relation with humans. So some animals, by their own will, come close to humans. So they begin a relation, and that was the way of domestication. Of course, that we begin to kill animals for food, but also wild animals for food. The problem, I think, that was that progressively we began to impose on these animals more a relation of an exploitative relation. So I don't consider that domestication per se is bad. But also, I don't consider, that is important to say, that domesticated animals are animals that should not exist. I think that wild animals, domesticated animals, and liminal animals have the same value. That is also, I think that if we have different groups now, they will, the state and the human beings should do everything to promote the flourishing of these animals according to their species and according to their individuality. I don't know if that is understandable. I hope that is.
I don't know, Macarena, if you wanted to speak to that as well.
So in Estrellita's case, the case, well, is focused on a woolly monkey. So that kind of explains why the court just focuses mainly on wild animals. But the thing is that is interesting about the Estrellita case is that when you start reading it, you start thinking like, oh, well, this case is just about wild animals. There's nothing for other animals. But the court, to reach the conclusion that Estrellita is a subject of rights, the court starts by asking the question, are animals subjects of rights? And the court says, yes, they are, because they are sentient in a strict sense, like humans. So they are subjects of rights. So in that sense, we could say that the court obviously is maintaining the status quo on animal agriculture and all these uses for animals, but is trying at the same time to recognize that wild animals have more rights. So in that sense, it's not weird to say that the court thinks that domesticating wild animals is wrong, but domesticating other animals isn't wrong. The court isn't even questioning this, because at the same time, the court is saying we should continue, humans can continue eating animals because humans are omnivores. So it's not even a matter of discussion in this case. For the court, it is clear that domesticating a wild animal is worse than what we did by domesticating other animals. Even if we could, morally speaking, challenge this assumption, but in this case, I believe it is different because, as Marcia said, dogs, for example, became domesticated thousands of years ago. So now, for example, when you observe your dogs at home, they also have certain needs, and some of these needs, I don't think involve like dyeing their hair pink or creating these really weird breeds where they don't smell or they don't bark, or that stuff is obviously wrong. But normal dogs in a house, like, they have certain needs that are different from a primate's needs, like a woolly monkey. Woolly monkeys haven't been domesticated for thousands of years next to humans. So it's very difficult for a human family to offer a woolly monkey the circumstances that animal needs to flourish or to live a life worth living. It's very hard because as we don't have the knowledge as humans to help these types of animals. We don't even in most cases, sometimes we even don't know how to offer dogs or cats that have been domesticated for quite some time now, the conditions that they really need. So that's why, like, I think the court just considers that it's worse to domesticate wild animals than domesticated animals.
Thank you. And we have a question from Eva.
We can't hear you, or I can't hear you. I don't know.
I'm
No.
sorry. You hear me now?
Yes.
Okay. I was saying that it is extremely interesting. Thank you for the presentations. I really enjoyed them. I have two small questions. First of all, about the implications for human rights, because somewhere in the judgment they also mention indeed that humans are also part of nature, if I remember rightly, and about the sentience. So could we then also argue that human rights should be interpreted via the ecological principle and multi-species principle as well? And then secondly, my question is about the habeas corpus, because that is now accepted for animals. So does that mean that for any animal in captivity, we can now start habeas corpus procedures in Ecuador? So that's my questions.
Yeah. Well, the implications for human rights, that would. The court didn't say that. I don't remember that the court said in the case that humans. The court said humans and animals are parts of nature. It said something like that, but he never said that the rights of humans also derive from the rights of nature, and that is unfair, no? Because if we want to protect environment, we should also put limitations on own rights for protect environment. But currently, with the Estrellita case and the Constitution of Ecuador, we have the rights of humans on one side and other guidelines of the state, like for instance, the goals of economic development, etc. And also we have separately the rights of nature. So these human rights, the objectives of the state, and also the rights of nature will be assessed independently. So I don't think that it will have an implication in human rights, but also it would be impossible, because that one of the characteristic of human rights is the moral progress, because we protect human health, that is protect from viruses, from dangers from the environment. We give assistance to people who is suffering from natural disasters. We protect even under the recognition of the autonomy. We recognize that people have the right to choose their own gender, their own ways to live. We don't follow a natural balance or natural progress of how nature works in human rights. Human rights give this protection, this sphere of individuality, of autonomy and protection against others to humans. And we want the same for animals. So I don't know if that answers your question.
So can I add something? So when the court started talking about the interspecies principle and the ecological principle, I really think the court just did that because they thought they were forced to say something about the slippery slope. You know, I don't think the rights of nature per se doesn't oblige you to talk about the interspecies principle or the ecological interpretation principle. The court just went that way to excuse, to say that, okay, I'm saying that all animals are subjects of rights. I'm saying that animals have now constitutional rights under the rights of nature, and that specifically wild animals have certain rights, and then mention other rights more general. But then they felt like they had to say something, but because most people say, okay, like the typical question, but what happens with animals in farms? What happens with this? What happens? Yeah. So the court came up with this whole argumentation to explain this. But actually, if the rights of nature actually could be used as an argument to end animal agriculture, because we know that animal agriculture is one of the main greenhouse gas emission sectors in the world. So eating animals really isn't justified by the rights of nature. That's something that we just want to continue excusing so we can continue doing it, but the rights of nature actually should imply that we move away from consuming animals and start eating plant-based food. That's what would be appropriate following the rights of nature framework. But we're not at that point in Ecuador, we're not at that point anywhere, really, not even in Europe. Like, we have to think that Ecuador, for example, in its constitution, it's very important for them to have to deal with poverty and to deal with feeding the population. So that's something that is included in the constitution that can explain why these themes come up in this judgment. And regarding what you asked about the habeas corpus, the court, this is really important, because the court said that the habeas corpus can be used under certain circumstances for animals that are in captivity. We have to find, obviously, I don't think this will include, for example, a cow in a CAFO or a dog in a house, but I think this can include, for example, it will include, for example, a wild animal that is kept in horrible conditions in a zoo. I think the habeas corpus in that case, for example, for a primate in a zoo, or for wild animals in general in zoos, or even in labs or circuses in Ecuador or whatever, I think those cases will mainly be cases that will be accepted by the habeas corpus. But even if the habeas corpus is only for those cases, I think that is a huge advance in itself, because usually countries say that the habeas corpus is a human right, and say that, like, not even if animals were considered legal persons, they would necessarily have the habeas corpus as one of their rights. So we have to see what happens in Ecuador. But the court left it open to use the habeas corpus.
Yeah, and not only habeas corpus, the court says that also for benefit animals, we can use other constitutional guarantees, other constitutional processes. And for instance, I don't know if that exists in the United States, but in Latin America, we have with habeas corpus, other processes, for instance, the process of protection. There are special processes that are so short that even don't have a probatory stage. So they act very quickly, and the judge give attention to these cases very quickly. So yeah, the animals from that point of view can benefit from these constitutional provisions.
Thank you. And we have time for one more question. This is from Daryl. Is sentience synonymous with suffering, an emotional state, or specific to pain sensation?
I can share. Macarena, do you want to say something? I have a...
Sentience refers to the capacity to experience negative and positive emotions like suffering or enjoying or pleasurable emotions. So it's the capacity that certain animals, including humans, have of interpreting the outside world in a subjective way through negative and positive states. So it's not only a physical sensation, it's also, well, it's subjective, So actually sentience is a cognitive ability, we could say, in that sense, that a lot of animals have. And that is the basis for arguing that animals have interests and rights. It's kind of like the minimum threshold for animal rights.
Yeah, and the case say that that is something weird in the case too. I think that well, we can and sentience is a term that we have a lot of domain when you are an animal lawyer, but I think that constitutional courts or constitutional judges or normal lawyers don't have so much, don't know so much this term, but the court says that there are sentient beings in the environment and refers to plants that have the ability to go towards the sun, etc., but says that animals are sentient beings in a strict sense. So we have, I think that there is only way to be sentient, and be sentient is only well, until we know in relation with the science, what science says is that only animals have. And I would like to, I don't know, the person who asked this, I would like to invite about to read about phenomenal consciousness, because when we refer to sentience, we are referring also to a very undefined term, because sentience is more than feel pain and suffering or pleasure. Sentience imply a cognitive processes inside, and there are different kinds of cognitive processes, but the most basic cognitive process is the phenomenal consciousness. And the phenomenal consciousness is present in the most of animals. And phenomenal consciousness gives to the animal the ownership of their own body. It creates in the mind of the animal an ownership that you have an own body that is auto-regulated, and you feel what happened with your body. You say internally, you send a message that this is happening to me. So to only for present a more concrete a definition of what is sentience, I think that we have to begin to talk more about phenomenal consciousness. It's only that.
I think that's all the questions that we have here. Thank you so much, Macarena and Marcia, for these wonderful presentations. And thank you all for joining us today.
Thank you.
Thank you. Thanks for the invitation. Bye.
Bye.